Commonwealth versus Aidan, Kearney.
Just reviewed all the submissions. Any witnesses for the Commonwealth?
No witnesses, just presentation of certain documents. I apologize, I have not had these this morning, I've shared them with my brother already.
It's all right. So, is there there's more things for me to look at?
Yes,
You don't have any witnesses?
no witnesses.
Do you have witnesses, Mr.
I have
Bridges?
two officers, Your Honor.
Is one of them Officer Krupp?
Yes.
No, have you reviewed the submissions by the defendant?
Yes,
Have you spoken to Officer Krupp yet?
yes. No, I have not spoken to Officer Crowe.
Don't you think you should?
Not really, Judge.
All right, give me your submissions.
Folks, quiet, please.
And just whenever you're ready for it, we have several objections on relevancy grounds to a lot of that, but just want to put that out there.
The good news is, if it's not relevant, it's not going to help anybody.
Okay. Self-executing objection, then.
All right, thank you.
Thank you.
All right, why don't we assume that I've reviewed these already? Get right in, oh, no, you call your witnesses now, I'm sorry.
Certainly, Your Honor. I would first like to call Judge Dedham Officer Matthew Kozak.
Good afternoon, officer. Could you raise your right hand? Do you solemnly swear in this matter now in hearing to tell the truth, the whole truth, and nothing but the truth, so help you God?
Your Honor, where would you like me to be while I examine Mr. Kozak? Thank you. I'm just going to stand over here. Can you hear me okay from here? Excellent, thank you. Officer, please state your name and spell your last name for the record.
Matthew Kozak, last name K-O-Z.
Give us your profession, description, and a little bit about yourself.
Been a police officer, but been with them for 10 years now.
Question. Directing your attention to 22624, it's been brought to your attention that you went to an alleged vandalism call right here in Dedham. That's actually the back parking lot behind the registry, correct?
Correct.
And what's the first thing you recall about that incident? How did you come to be asked to go there?
With dispatch, I was on a call, I'm on Route 1 over dispatch. The call behind the fair amount of people, 4 or 5 people standing around the vehicle.
What was the nature of the call, first of all?
Malicious damage to a motor vehicle.
Can you recall that the time you received the call was 2:32 p.m.?
I wouldn't dispute that.
You record that in your reports, right? And the report says 2:32, so that's what it would be, right? And the report also says 2:47 cleared.
Correct.
And that means that when the call's over, right?
Yes.
So you're out of there about 2:47. 2:47 p.m. you're out of there.
Yes.
Okay. So about 15 minutes you spent with the complainant, right?
Correct.
All right. And did she indicate to you anything about where she had been and what she was doing? She was with a group of other people as well, yes?
Correct.
And were you able to ascertain who those other folks were, just in terms of why they were there, what was their relationship to the hearing or anything like
I
that?
didn't get in depth with them at all.
And as far as you knew, you were there to investigate a vandalism call, yes?
Correct.
All right. And what did you do with respect to investigating the vandalism call?
We did that. That was towards the end of the day, so nothing that particular day. And then the registry of deeds.
Save you the time on that. You looked into some video around and nothing came of it, right? Okay. Just rewind back to the day in question, and you're at the scene. Did you look at the car for supposed vandalism?
I did, yes.
All right. Did you take some pictures of it?
Correct.
All right. And you had a conversation with the complainant, right?
Yes.
everybody was sort of adding things and chiming in and talking to you, trying to give you information.
Correct.
And then afterwards, reflected in your police report, as best you can.
Yes.
All right. And did you ask the complainant, and that's Ms. Lindsay Gattani, correct?
Yes.
Did you ask Ms. Gattani anything about who might have an interest in doing something like this to you, or anything to that effect?
Yes, that's in there.
What were your words? What did you
I can't
say?
remember exactly what I said, but, it did be something. Or anyone of interest or something along those lines that you may think would.
Right. And what did she say?
And the consensus was that it could possibly have been Mr. Kearney or.
And did Ms. Gattani say anything relative to a restraining order?
So she did at one point say she had a restraining order or something.
So between 2:32 p.m. and 2:47 p.m., after leaving the courthouse, she went to the car, saw damage, told you that she had a restraining order against Mr. Kearney. Did she say anything about him taunting her, calling her a liar, violating the order at all?
Yeah, I don't recall anything along those lines. Question.
Okay. So if she had said something that important, you would have reflected it in your report, right?
Correct.
And we agree there's nothing in your report to the effect of anything about restraining orders, right?
Correct.
Okay. What was her mood at the time?
She seemed pretty quiet. She was sort of the furthest away from me out of the group.
What about all the other folks there? Were they also offering information too?
Not really. They were speaking, but none of it, for my sake, what I needed to see was the camera footage, so that's what I was focusing on. So I knew I wasn't going to speculate as to who.
Did she say anything to you about Mr. Kearney violating the order she mentioned just prior to that?
Negative.
Say anything about him taunting her or calling her a liar? And if you did remember, that's something that's so important that you would have either arrested the gentleman if he was around, or certainly reflected it in your report, right?
Correct.
And there's nothing to that effect anyway, right?
Correct.
Thank you very much. Nothing further.
Process elimination.
Officer Matthew Kozak. Crump, I'm sorry, Crump.
solemnly swear in this matter now in hearing, to tell the truth.
May I inquire? Officer Crump, please state your name, spell your last name.
Officer Brian, Sierra,
You're a Denton police officer?
I am,
How long have you been so employed?
25 years.
And you've been asking questions in the last couple of days and last week regarding an incident that happened back on 2/26/24, right?
Yes.
And the incident involves you as a Dedham police officer on duty, correct?
Correct.
And tell us what your assignment was, just in general, that day, that afternoon, after 2 o'clock.
I was assigned outside,
And there were a lot of people milling around that day, yes?
yeah, definitely a business.
There was a hearing that day relative to the case involving the Commonwealth versus Kearney in Norfolk Superior Court, correct?
Correct.
All right. And your assignment was to direct traffic in the crosswalk.
Correct.
At some point, did you encounter the gentleman to my right?
I did.
And for the record, who is this and where did you encounter him? And what would you say his mood was as you were able to observe at the time? Happy, sad, confident, angry, upset, anything?
It was a brief conversation.
What did he tell you?
He said that there was, someone was concerned.
Was he looking to you for guidance or what to do about it?
Yeah, I think he, as he was coming across the street, I remember kind of turning, moving away. I interrupted him, he wanted to go far enough away not to be a violation. Moving away toward the registry of deeds.
Where did he go after that, to your observation?
I kind of remember him heading up toward, like, maybe the steps or toward, like, Asia.
Recognizing that you're very busy in that intersection, and I think we all know how that intersection is on days like this.
Once he cleared, that's when I just got traffic.
Yes, sure. He gets through. At any point in that afternoon, did you notice him any further that day? So it's fair to say you didn't hear him yell liar to anyone or taunt anyone or anything to that effect, correct?
What's the grounds for your objection?
Judge, he's basically testifying.
No, he's asking him a question.
That overrules.
Folks,
I don't recall that, but I mean, it was noisy, a lot of people, but.
Would you say that Mr. Kearney was trying to circumvent the order or making a good faith effort to comply with the order, based on your observation?
No offense, witnesses' opinions don't count.
Thank you, Your Honor. Nothing further.
Fact-based,
Nothing further, thank you.
cross-examination.
Your direction was very. More directly watching everything he did, every move he made, correct? Right, over the 6 seconds.
Nothing further, Your Honor. Thank you.
Thank you, sir.
Thank you, Officer.
Any other witnesses?
No witnesses.
All right, any other submissions?
I submitted quite a few documents to our.
You just submitted these.
Yes.
And I already reviewed the other submissions. Anything else?
I have a thumb drive, Your Honor, and I understand that thumb drive fits.
No, you don't have to give an opening. You want me to look at the thumb drive. Are there any other things either party wants me to look at before we give finals?
I'd just like to make sure that I have a copy of what's on that thumb drive.
Okay, got it. Anything else? All right, so I'm gonna take a short recess, look at the thumb drive, the new submissions.
Yes.
We'll make sure you have the.
Thank you, Your Honor. And I do have 3 quick affidavits I'd like to submit, Judge. The first one is an affidavit of Meredith O'Neill, and I know you're going to read it, and it speaks for itself.
Yep.
The second thing I'd like to proffer is communications from Ms. Gattani to my client dated 3/7 and 3/11 via text that I would argue amount to witness intimidation and extortion.
Also, what's next?
And the third thing, Judge, is proof that on...
Yep, I don't need your characterization. You folks are gonna have
All
a
right.
chance to characterize all this evidence at the end.
Sure.
Just give it to me.
February...
Just give it to me.
Okay, it took me a little while to figure it out, but I have confidence you'll figure it
You're
out.
gonna do that in the closing if you
Thank
think I need some guidance.
Thank you very
Are
much.
there any other things? All right.
All right. This court's back in session, may be seated, please remain quiet in the courtroom, thank you.
Hear from you, Mr. Noel. Your Honor,
The basic facts are pretty clear. Mr. Kearney was across the street from the Superior Court, when Mr. Kearney left the building. He had a 6-second interaction with an officer and said, am I okay here? Officer said, yes, you are. There was no further discussion about when somebody came out, when somebody walked by, or whatever the case may be. Here, the photographs provided to Your Honor clearly show Mr. Kearney at different locations in front of the Registry of Deeds. It's clear that he's following and photographing Mr. Kearney from his location, including hiding behind the bushes, hiding within the bushes to photograph her as she left Superior Court. He was easily less than 100 feet away. I believe one of the measurements Your Honor has shows he was 75 feet away from her location. He knew exactly what he was doing. Mr. Kearney is not one to act out of an abundance of caution, Your Honor. He pushes the envelope as far as he possibly can, consistently. If I may, Judge, and parenthetically, before I forget this, Your Honor was presented with what will purport to be text messages from Mr. Kearney to Mr. Kearney that were recently allegedly made. Mr. Kearney would surrender her phone to the court for purposes of evaluating whether or not her phone sent those messages. She absolutely denied it. And the fact that...
Yeah, that really isn't part of the evidence. You were, a little while ago, objecting to affidavits. They're hearsay. This isn't even hearsay. So you're not going to argue things that weren't in here.
That was submitted to Your Honor.
No, you just told me about what the evidence is. What you just said wasn't part of this. Go. Stay with the evidence.
The evidence is, Judge, that Mr. Kearney knowingly was less than 100 feet away from Mr. Kearney on several instances during the course of the afternoon, the course of the morning afternoon. He knew she was there. He knew there was a restraining order, ordered to stay 100 yards away.
Where's the danger?
It doesn't have to be danger, Judge. No danger whatsoever is required. The
For
order,
pretrial detention?
oh, in terms of the pretrial detention,
That's the motion you were arguing?
with the pretrial detention, Judge, the danger is that Mr. Kearney has consistently harassed this woman online, continues to do so today. Your Honor has
Where is the physical danger?
Your Honor has the thumb drive, where Mr. Kearney is saying, I will be far more dangerous when I get out. He made that statement when he was incarcerated. I will be far more dangerous when I get out. He has a number of instances here, Judge, where, in the context of the documents that you were given, he has set up a Pornhub account. He set that up himself. Aidan Kearney at Pornhub for Mr. Kearney.
Physical danger.
It's not a
For pretrial detention, it's a physical danger standard.
The physical danger is that he keeps stalking this woman. We do not know what's in his mind, what he's going to do. If he can't follow the court's order, Judge, and has historically not followed court orders, there is a danger there. We don't know what's going through his mind, why anyone who would violate an order so consistently as he has. I mean, he speaks about his, and some of the documents I gave you, Honor, about his mental issues, saying he doesn't have a gun because he doesn't know what he would do if he had one. Those are all big concerns. And, I mean, he has a car. God knows he can get his hands on another weapon. And he continues to stalk this lady, continues to harass this woman online. It's almost on a daily basis, Your Honor. And she is terrified. She's absolutely terrified of this. In terms of the danger, that's basically the danger, Judge. He's had a number of people who he's intimidated, according to the grand jury, several cases, outstanding charges now of intimidating a witness, conspiracy to intimidate witness, and with respect to this particular individual, Judge, Mr. Bradle came before this court, and I'm not in any way suggesting that Mr. Bradle was aware of this, but he came before this court and presented a recording that purported to be, start with this defendant saying, I'm still recording, and then a long conversation, if you will, between the defendant and Mr. Kearney. The defendant was subsequently indicted for illegal interception of oral communication with respect to that. And the Commonwealth has...
That's not physical danger. Focus on physical danger because you're asking me to hold him because he's too physically dangerous. Go.
I believe he's physically dangerous, Judge, simply because of what I've indicated to you.
All right.
The fact that he consistently goes after this woman, those are not the actions of a normal mind. To continue to harass somebody like that, to continue to follow them, to stalk them in front of this building, those are not normal reactions, okay? And Judge, that suggests a physical danger. In addition to all of the other charges he's amassed, there is a physical danger, Judge. This is a woman who came before this court, obtained a restraining order, indicated she had been assaulted by this individual, and basically, she's terrified of her. That's the physical danger, Judge. Physical danger is created by him and his actions and his stalking and everything else. And when somebody says, I don't own a gun because I have mental issues, right? Compounded with his stalking her, that's a physical danger.
All right, thank you, Mr. Gray.
All right, thank you very much. May it please the court. Judge, there's no danger here in addressing what Your Honor is talking about. He has no record. This case involves an alleged being within a sphere of distance. She came into his distance, Your Honor. He left. He tried to avoid it. And in fact, the record shows, and I'm sure you picked this up, Judge, she didn't see him. He didn't see her. She reconstructed this thing later on. And then you can see in the 68-page filing as well, she changed her story when she realized that Mr. Kearney went to the police and showed video to the police wherein she doesn't react to him, according to the officer. She doesn't know he's there. Then she writes the 68-page thing contradicting herself, saying, oh, maybe it wasn't him. Maybe I didn't hear him say that. I'm not sure. Okay? So she said it at the time because she knew that she had to say that he tried to get to contact her at the time. It's an absolute lie. She got caught lying. She's an absolute liar. She's a deranged individual who had... Counsel talks about stalking. Stalking has a legal definition. The only person that can make out the legal definition of stalking is her on Mr. Kearney. Mr. Kearney's never been dangerous. He's never harmed anyone. He has no issues with harming anyone. All he's ever done is tell people to tell the truth. Everything else in their submissions, Judge, involves that they don't like his journalism. Everything else is completely baseless, absolutely not a basis to establish any physical danger whatsoever, because Mr. Kearney, his entire life, has never been a dangerous person in any way other than his journalism, frankly. So that's what we're talking about here is the government and Ms. Kearney, working in concert, have tried to do nothing but suppress his journalism under this phony guise that he's dangerous. And incidentally, Judge, counsel didn't address this, but this court had an assault and battery complaint against Mr. Kearney. The government didn't even indict it, it was so flimsy. They abandoned it and left it here, and it was null process. The allegation was that Mr. Kearney was struggling with Ms. Gattani for about a second, trying to get his notes back that she took from him, and that she fell onto the couch. That was the only allegation anywhere in the galaxy related to Mr. Kearney about alleged violence, and they abandoned it. Thank you, Herm.
I appreciate arguments by both counsel after hearing review of the evidence. The motion is denied. The defendant's going to be on personal recognizance with the new... Stay away from contact with the alleged victim. You want to be heard on your motion?
Folks, quiet, please.
All right. Mr. Barboza, if anybody does that again, they're right.
Yes, Your Honor.
Go ahead.
Your Honor, with respect to the motion to revoke bail, Mr. Kearney has two separate, if you will, sets of charges pending in the Superior Court. He was given the regular bail warning when he was released from the Superior Court on personal recognizance. He has managed again to have additional charges brought against him in this court today. Your Honor, found probable cause for those charges, and I suggest that is sufficient, Judge, for this court to revoke Mr. Kearney's bail for a period of 60 days on both of the cases that are pending before the Superior Court, and I would ask Your Honor to do so.
Mr. Gray.
Your Honor, the government's argument flounders on the same rocks. There's no issue of future danger. He's never been dangerous. There's no risk of danger. There's no danger alleged in this incident here. This also implicates the quality of the allegations, and that's roundly addressed in all of our submissions, that this is based on lies, that she is caught lying, that Mr. Kearney violated the order by yelling at her, everything else in the case shows that he was trying to avoid contact, in total good faith, trying to stay away from her, and she came into his sphere, she came into his courthouse. Thank you, Your Honor. Nothing further.
All right, after hearing that motion is denied. Mr. Brady, you want to be heard on the motion to dismiss, is that right?
I do, Your Honor.
All right, and, you're ready to be heard on that?
I'm in here.
All right, I'll hear from you, Mr. Brady.
Thank you very much, Your Honor. So, Judge, typically in this situation, and I think the situation speaks volumes about the quality of the allegations, Your Honor.
But just to make sure both counsel understand what I'm going to be reviewing, it's a snapshot of what the magistrate had at that time. There isn't like the equivalent in the civil world of a motion for summary judgment.
Judge,
This is the snapshot
Yep.
at that time. Go.
Okay, I appreciate that, Judge. I want to back you up, if I may, respectfully, back to when the officer approaches the magistrate for the issuance of process. What do we have? We have a misdemeanor where he's not subject to arrest. 218-35A specifically says that he's allowed to have a clerk's hearing in that circumstance. There are 3 exceptions. Here, if we look to the paperwork, you'll see the paperwork does not make a finding that satisfies any of the exceptions. If you look at the bottom of the page, Your Honor, and I just have a moment to pull that out.
Yeah.
And it's the page from the docket, or from the file indicating application for criminal complaint, Your Honor. And you'll see at the top, the officer, or the boxes that purport to be the officer asking the courts on the top. It says, only misdemeanors, without notice, commission of a crime, and that's what's checked on top. So then the magistrate receives the documents, and the magistrate here deprives Mr. Kearney of a clerk's hearing. So you have to see if the circumstances and the findings, these boxes on the bottom are the court's magistrate's findings. And the magistrate's findings do not reflect the exception that they're trying to use. The exception is no clerk's hearing when there's an imminent threat of a crime, of a future crime, the commission of another crime, not the crime we're looking at here, a future crime. So it's 2 things. It's threat of a crime, but an imminent threat of a crime. And as we know, statutes and words in statutes need to be given their ordinary meaning, Your Honor. And the meaning of imminent, and I'm going to read it because I don't want to get it wrong.
Well, the alternative for imminent threat is either bodily injury, crime, or flight by the accused.
Right, but look, the only thing that they've checked is crime.
Right. Well, so it's implicit that it was one of those 3 options for imminent threat.
It's not, it's an incomplete finding, Your Honor. It says, applications decided without notice to the accused because, it just says crime. The crime itself is not a
Just argue the merits instead of that technicality of a box, because the crime box is checked off.
Right,
I understand, I see what you're saying.
imminent threat is not checked off, Your Honor. They have to make that finding.
Yeah.
The finding was not made.
Yeah.
It's not a close call, Judge. They have to make the double-pronged finding, imminent threat of the commission of a future crime. This is the government's documents, Judge. Okay, we're not here to speculate on what is the government, what do they mean? Okay, that's not part of this. They're trying to lock up my client here. They're trying to deprive him of what I say is a due process right.
It was a summons. This is a summons, not a lockup. Go.
When I say that, I mean broadly the government,
No, but
including
we're
the prosecution.
talking about this
The
issue.
court is trying to deprive him of his right to a clerk's hearing. That's what this is about here.
Yep.
And I'm sorry to speak broadly. I mean that the court's not trying to lock him up. The government as a whole is trying to lock him up. But here, the court is trying to deprive him of his clerk's hearing. And the court did not make the proper finding. The court has boxes here. If there's an imminent threat of the commission of a future crime, they need to make the finding there's an imminent threat. They did not make that finding. Mr. Kearney is entitled to dismissal, and if the government wishes to commence this thing, get this thing off the ground again, let's bring it on, but let's do it at a clerk's hearing, which is what his right is, Judge, because the clerk's hearing performs so many valuable functions here, Judge, and you saw my filing, I'm not going to reiterate it, it's in the triple own case, but also, Judge, clerk magistrates have to rely on, and they do, I see that them doing it every day, rely on reasonably trustworthy information is probable cause. And so here, there's no reasonably trustworthy information, and Mr. Kearney was deprived of the opportunity to present that to the court and say, look at our video, look what she said in the report. She said that Kearney yelled liar, she said that Kearney was screaming at her, and that she saw him and that she perceived him.
The magistrate didn't have that information at the
Right.
time, that the magistrate found that there was an imminent threat of a crime.
Right.
I know you're saying, but she didn't check off the first part. It's implicit that that's what it was. Go ahead.
There's a box to, okay, I'm not gonna argue with it, right, you're the judge, you make the finding, I appreciate that, I respect it. In terms of the merits of the case, Judge, the merits of the case don't speak to any future danger. They don't support a finding that, Mr. Kearney is likely to cause, imminent serious future harm to anyone.
No, just a crime. In other words, the magistrate didn't check off the bodily injury, Mr. The magistrate checked off the crime.
Right, and didn't check
the concern,
imminent threat.
obviously, from your point of view, is he has these charges across the street.
Yes, the charges across the street, Your Honor, are based on emotional harm. The witness intimidation statute, as I'm sure the court's well aware, 13B, says emotional harm. All of these,
But this isn't, the magistrate didn't check off bodily injuries.
right, I'm sorry, Judge. I'm sensing that you want me to not argue anymore on the imminent threat issue.
Well, no, but on the, it's the threat of a future crime that the magistrate found.
Imminent threat, Judge.
Yeah.
They did not find imminent threat. This box is not checked. So we can't speculate that, oh, they meant to check imminent threat. You're filling that in, Judge.
Well, there's no other reason to fill out this form if that's not what it was.
There's a box to check when they need to make that finding. So they didn't make it finding. That's my argument. So in terms of, so putting that aside, Your Honor, whether we revoke the bail, the quality of the allegations are relevant and matter. And the quality of the allegations, I think, have been alluded to and vetted out here. And the quality of the allegations, whether you would lock someone up for this case on a bail revocation, is ridiculous in the sense that the case is shown to be false. Ms. Gattani went to the police and said, he was telling me I was a liar. And then she backs off it in her 68-page submission, only because Mr. Kearney called her out on it, and because we had video, thankfully. And so that's the lack of quality here, Judge. And especially the other thing is the nature and circumstances of the offense, in the sense that this type of a crime for someone with no record would never result in Mr. Kearney going to jail. So it would be deeply unfair to Mr. Kearney for the court to lock him up pre-trial on a case where he's not dangerous, on a case where he wouldn't go to jail. So again, I ask that you not revoke any bail and that you allow him personal recognizance. Thank you.
On the motion to dismiss.